5, 4, 3, 2, 1, start. Appellant has been convicted under sections 325 IPC by the trial court and sentenced to undergo rigorous imprisonment for 6 years with fine of rupees 10,000 and in default of payment of fine to undergo rigorous imprisonment for 3 months under section 304 IPC full stop. Both the sentences have been directed to run concurrently full stop. This judgment which is under challenge in this appeal full stop. Factual matrix as unfolded is that Sri Bal Krishan was the owner of two buses bearing registration numbers DL3PA5282 and DL3PA5303 full stop. Appellant was driver of bus number DL3PA5282 while Praveen, brother of deceased Naveen, was working as a driver on bus bearing registration number DL3PA5303 full stop. Deceased was working as conductor on bus bearing registration number DL3PA5282 of which appellant was driver full stop stanza. Both these buses used to be parked in the night at Mill Chowk full stop. On 25th August 2005, buses were parked at Mill Chowk full stop. After taking meals, appellant deceased and Parveen were resting on the roof of the bus full stop. At about 1 a.m., a quarrel broke out between the appellant and deceased over the settlement of account full stop. Appellant commanded that money be paid to him immediately full stop. When deceased told appellant that he will pay money later, appellant pushed him from the roof of the bus full stop. Deceased fell down on the ground, sustained fatal injuries on his head and back to which he succumbed at the spot itself full stop. When PW2 asked the appellant as to why he had pushed his brother, appellant pushed him also from the roof of bus full stop. PW2 fell down on the ground and sustained grievous injuries full stop. Charge under section 302 IPC was framed against the appellant on 22nd December 2005 for causing death of Naveen full stop. Charge under section 325 IPC was also framed against him same day for causing grievous injuries on the person of Praveen Kumar full stop. Appellant pleaded not guilty to the charges framed against him and claimed trial full stop. After the prosecution closed its evidence, statement under section 313 CRPC of the appellant was recorded wherein entire incriminating material which had come on record was put to him full stop stanza. Case of appellant is that of simple denial full stop. He claimed that he had been falsely implicated full stop. He did not lead any evidence in his defense full stop. PW2 is the injured. He had also witnessed the appellant pushing the deceased from the bus full stop. PW2 has fully supported the prosecution story full stop. His testimony has been found trustworthy and reliable by the trial court to conclude that it is the appellant who had pushed the deceased from the roof of the bus, resulting head injuries to him as a consequence whereof he died at the spot itself. Further, appellant had caused injuries on the person of PW2 by pushing him from the roof of the bus full stop. Keeping in mind the fact that appellant deceased and the injured were friends, had taken liquor and meals together, quarrel broke out between the appellant and deceased. All of a sudden, trial court was of the view that intention on the part of the appellant to cause culpable homicide of the deceased cannot be inferred full stop. However, it was held that knowledge on the part of the appellant that by this act of pushing the deceased from the roof of the bus was likely to result in his death cannot be ruled out. Full stop. Stanza. Throwing a person from the roof of a bus was a dangerous act and cannot be termed as accidental. Full stop. Appellant had pushed the deceased in order to teach him a lesson since he had failed to hand over the money on that day itself. Full stop. This aspect was further strengthened from the fact that when PW2 confronted the appellant as to why he had thrown his brother from the roof of the bus, appellant pushed him down also. Full stop. The repetition of this act ruled out the possibility of appellant accidentally pushing the deceased from the roof of the bus. Full stop. Trial court concluded that since there was no intention or mens rea brought out from the evidence laid on record, no case was made out under section 302 IPC as also 304 IPC. Full stop. Thus, appellant was convicted under section 304 IPC for causing death of deceased Naveen. Full stop. He was also convicted under section 325 IPC for causing grievous injuries on the person of Parveen by pushing him from the roof of the bus. Full stop. I have carefully perused the statement of PW2 and find that he has fully corroborated the prosecution story. Full stop. Stanza. He has categorically deposed that after the buses were parked at Mill Chowk, he, along with appellant and deceased, had taken meals. Full stop. Thereafter, they were resting on the roof of the bus. Full stop. A quarrel took place between the appellant and deceased on the point of payment of money. Full stop. Deceased told the appellant that he would pay him later on. Full stop. However, appellant was adamant that money should be paid to him immediately, and when deceased expressed his inability to do so, appellant pushed him from the roof of the bus. Full stop. Deceased fell down on the ground and sustained head injuries to which he succumbed at the spot itself. Full stop. When he asked appellant as to why he had pushed his brother down, appellant pushed him also. Full stop. He fell down on the ground and sustained grievous injuries. Full stop. This version has remained unsettled in his cross-examination. Full stop. No material discrepancy could be pointed out by the learned counsel for the appellant in his testimony during the course of arguments. Full stop. The version given by PW2 while in witness box is in conformity with his statement contained in the FIR. Full stop. In my view, trial court has been right in accepting his testimony to conclude that it is the appellant who had pushed the deceased from the roof of the bus, resulting in his death after a quarrel broke out between them over the payment of money. When PW2 confronted him as to why he had pushed his brother, appellant pushed him also from the roof of the bus, resulting grievous injuries to him. Full stop. Stanza. As per post-mortem report exhibit PA2, following injuries were sustained by the deceased are external injuries: laceration, avulsion over right frontoparieto-temporal region. Full stop. Grazed abrasion over lateral aspect of left knee. Full stop. Possibility of knockdown from the roof of the bus as alleged cannot be ruled out. Full stop. Craniocerebral injury was sufficient to cause death in ordinary course of nature. Full stop. Medical evidence thus corroborates the testimony of PW2 that deceased on account of having been pushed from the roof of the bus by the appellant fell down on the ground and sustained injuries on his head which ultimately caused his death. Full stop. Stanza. MLC Exhibit PA1 Praveen shows that he had sustained interior compressed fracture of L2 vertebra. Full stop. Vertebra. Full stop. Doctor has opined the injuries of PW2 as grievous full stop. From the evidence adduced on record, it has been proved that by his acts appellant had caused grievous injuries on the person of PW2 full stop. Learned counsel for the appellant has vehemently contended that from the MLCs of injured and appellant it is clear that they had consumed liquor full stop. PW2 has nowhere stated that there was previous enmity between him, deceased, and the appellant full stop. Appellant, deceased, and the injured were resting on the roof of the bus after taking meals full stop.